In law, timing rules can matter just as much as the underlying complaint. That's the heart of Coney Island Auto Parts Unlimited versus Burton, the Chapter 7 trustee for VistaPro Automotive, a case that asked whether you still have to act within a reasonable time even when you say a court judgment was never valid in the first place. The Supreme Court said yes. The justices ruled that the reasonable time limit in Federal Rule of Civil Procedure applies even to requests made under the specific rule where a party argues the judgment is void. The court pointed to the plain text and structure of the rule, and it affirmed the Sixth Circuit's denial of relief, especially because the petitioner did not argue that it met the reasonable time requirement. Justice Samuel Alito wrote for the court, joined by Chief Justice John Roberts and Justices Thomas, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson. Justice Sonia Sotomayor agreed with the outcome but wrote separately, concurring in the judgment. We'll dig into why that small phrase, reasonable time, can decide who gets a second shot in court and who doesn't. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. The Supreme Court just resolved a major disagreement among federal appeals courts about how long someone has to challenge a court judgment that should never have been entered in the first place. In the decision, the court held that even when a judgment is completely invalid, what lawyers call void, you still need to challenge it within a reasonable amount of time. Back in 2015, a bankruptcy trustee named VistaPro won a default judgment against Coney Island Auto Parts. A default judgment is what happens when someone gets sued but doesn't show up to defend themselves, so the court automatically rules for the other side. 5.5 years later, in 2020, Coney Island came back to court asking to erase that judgment. They argued the judgment should never have existed because VistaPro didn't properly notify them about the lawsuit in the first place. Under bankruptcy law, there are specific rules about how you have to serve legal papers. And Coney Island claimed VistaPro didn't follow those rules. The lower court said no. Even if the judgment was technically void, waiting 5.5 years was simply too long. Coney Island appealed to the Supreme Court, which agreed to hear the case because different federal appeals courts had been giving different answers to this question. Coney Island's lawyer made what seemed like a logical argument. If a void judgment never legally existed in the first place, how can there be a time limit to challenge it? It's like saying there's a deadline to point out that an imaginary thing isn't real. He also raised concerns about fairness. If a court enters a judgment against you without properly notifying you, shouldn't you be able to challenge it whenever you discover it? The bankruptcy trustee's lawyer countered with a straightforward reading of the rules. The Federal Rules of Civil Procedure is the rule book that governs how federal lawsuits work, and it states that motions to vacate a judgment must be filed within a reasonable time. If the rulemakers wanted void judgments to be challengeable forever, they would have said so explicitly. In fact, there's another part of the rules that do allow unlimited time for certain types of challenges, like when someone commits fraud on the court. The absence of similar language for void judgments is telling. She also pointed out the practical problems. The trustee had relied on what appeared to be a valid judgment for years and spent money trying to collect on it. Meanwhile, the people who could have been served properly to restart the case might no longer be available. Allowing challenges decades later creates chaos and unfairness for everyone involved. Justice Alito wrote the opinion for 8 justices, and the reasoning was remarkably straightforward. The rule says a motion under Rule 60B must be made within a reasonable time. A motion claiming a judgment is void falls under Rule 60B-4. Therefore, it must be filed within a reasonable time. End of story. The court looked at how the rules are structured to support this reading. When the rulemakers wanted to create exceptions to the reasonable time requirement, they did so clearly. For example, some types of challenges have a strict one-year deadline. Others, like fraud on the court, can be brought at any time. The fact that void judgments don't have an explicit anytime provision suggests they're subject to the default reasonable time requirement. The court rejected Coney Island's philosophical argument that void judgments exist outside of time. Justice Alito pointed out that a mistake is a mistake whether you challenge it immediately or years later. But that doesn't mean courts can't impose deadlines for raising those challenges. The question isn't whether the judgment is truly void, but whether there's some legal principle that guarantees you can challenge it forever. Since Coney Island didn't argue the Constitution requires unlimited time, the court found no such principle. Importantly, the court noted that the reasonable time standard already provides flexibility for people who genuinely didn't know about a judgment. In cases where someone was never properly notified, it might be perfectly reasonable to wait until they learn about the judgment through enforcement efforts. This built-in flexibility addresses fairness concerns without creating an unlimited window. Justice Sotomayor agreed with the outcome but wrote separately to criticize one aspect of the majority opinion. She thought the court went too far by discussing whether the Constitution might require unlimited time to challenge void judgments. Since Coney Island explicitly said they weren't making a constitutional argument and nobody briefed the issue, Sotomayor believed the court should have stayed silent on that question. Her separate opinion reflects a philosophy that courts should decide only what's necessary to resolve the case at hand. This case highlights an important distinction that often gets confused. Whether a judgment is invalid is a different question from what procedures you must follow to get relief from it. Coney Island's argument mixed these two ideas together. They essentially said, this judgment is void, therefore normal procedural rules don't apply to challenging it. The court firmly separated these questions. A judgment might be completely invalid in theory, but you still have to follow the proper procedures to get a court to officially recognize that invalidity. The reasonable time standard provides meaningful flexibility that a fixed deadline wouldn't. Imagine someone who genuinely never received notice of a lawsuit and only learns about the judgment years later when someone tries to collect on it. A court could reasonably find that challenging the judgment at that point is timely, even if years have passed. The standard allows judges to look at the specific circumstances rather than applying a one-size-fits-all rule. On the other hand, someone who knew about the judgment, received demand letters, and simply sat on their rights for 5 years would have a much harder time arguing their delay was reasonable. The Supreme Court left several questions unanswered. Most importantly, they didn't actually decide whether the judgment against Coney Island was truly void. That wasn't the question before them. They only decided whether the challenge came too late. The court also didn't address what time limits might apply to other ways of challenging judgments outside the standard motion process. The rules preserve something called an independent action, essentially filing a whole new lawsuit to challenge a judgment, and the court didn't say whether time limits apply there. Finally, while the court hinted at its skepticism about constitutional challenges, it didn't definitively rule on whether the Constitution might require unlimited time to challenge void judgments in some circumstances. The majority noted that giving someone a reasonable amount of time might be all the Constitution requires, but that question remains open for a future case where it's properly raised. This decision brings clarity to a question that had divided federal courts. You can't wait indefinitely to challenge even a completely invalid judgment. The reasonable time requirement applies across the board, though what counts as reasonable will depend on the circumstances, particularly whether you knew about the judgment and had a fair opportunity to challenge it earlier. For people facing judgments they believe are void, the message is clear. Act promptly once you learn about the problem. The law provides flexibility for genuine cases of lack of notice, but it won't tolerate strategic delay or sitting on your rights for years. Find us online at 9robes.ai. That's the number 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.